Hello, welcome to the New Thinking on Investment Treaties series. I'm Jason Yackee, an Associate Professor of Law at the University of Wisconsin Law School. Today I'm going to present a brief discussion of some ways of thinking systematically about the costs and benefits of including investor-state arbitration in free trade and other kinds of treaties. My talk is based upon a series of papers that I co-authored with Drs. Laug Poulsen and Jonathan Bonilla. Now, the starting premise here for my talk is that for states to make rational decisions about committing themselves to treaty-based investor protection provisions, it's essential to give some thought to how one might measure the costs and benefits of doing so, and whether the benefits are likely to outweigh the costs. Unfortunately, evidence suggests that many states have not given much of any rational thought to their investment treaty programs. My presentation and the research upon which it is based is intended to provide states with the tools to undertake investment treaty decisions with more awareness of whether entering into such treaties is actually in their interest. I'll first provide an overview of the basic analytic framework, and then I'll go on to provide an illustrative application based around a hypothetical investment treaty between the United Kingdom and the United States from the perspective of the UK government. And while I focus on a bilateral treaty in this presentation, the analysis is easily expandable to the case of a multilateral treaty with an investment chapter, such as TTIP. And in fact, the framework that I explain here was developed specifically to aid the UK government in thinking about investor protection in TTIP. Now, you should understand that the framework is limited in the sense that I only address the costs and benefits of investment protection provisions. That is, grants of substantive rights like fair and equitable treatment and full protection and security that are enforceable by investor-state arbitration. The analytic framework does not address the potential costs and benefits of investment liberalization provisions, such as provisions requiring states to open up previously closed sectors to foreign investment. I also only discuss the main types of potential costs and benefits. A more nuanced analysis is provided in the underlying research papers that are cited on the concluding slide of the presentation. So let's go to our first slide to lay out the analytic framework in the abstract. Now, to start, we can think about the costs and benefits of investor protection provisions in terms of both economic and political costs and benefits, giving us a handy 2x2 matrix. Now, for economic benefits, most commentators suggest that the most important potential economic benefit is that the treaty will promote FDI flows to the host economy by reducing the risk of adverse policy changes, things like expropriation and the like. And so here the basic question is, how likely is the treaty to promote these new investments? How much new investment is likely to be promoted? What sectors or kinds of new investment are likely to be promoted? Let's move on to the next cell in our matrix, looking at economic costs. Now, for economic costs, the main cost that we focus on in our research is the possibility that the treaty will result in investment treaty claims against the host state government. As a side point, I should mention here that for investment chapters and multilateral FTAs, we would also need to think about how the investment chapter might divert FDI between FTA members. That's an issue that I'm going to ignore here. And so with an investment treaty, the host government is going to have to invest in building a defense capacity. It will have to pay tribunal costs and lawyers' fees. And most importantly, if it loses, it will have to pay damages. As the Philip Morris claim against Australia indicates, investor claims can in some cases amount to billions of US dollars. Empirical studies suggest that it typically costs each side in an investor-state arbitration $4 million in legal fees on average. The cost can, in certain cases, be much higher. The point there is that even if a state wins an investment treaty claim, it will typically have to pay some sort of litigation cost. Now let's look at the political side of things. Now, the literature on investment treaties often claims that the primary political benefit of investment protection is that it helps to depoliticize investment disputes. Now, the concept of depoliticization is fuzzy, and authors rarely define what they mean by it, aside from references to the threat of gunboat diplomacy in the absence of investment treaties. We can think about the concept as being essentially concerned with preventing investment disputes from becoming a source of friction at the intergovernmental level. Now, assessing the scale of this benefit requires difficult judgments about the manner and frequency in which the partner state would challenge the treatments of its investors in the host state. You'd have to think about the ability of the treaty to reduce such interventions. You'd have to think about the level of diplomatic discomfort caused by such interventions. And now our last portion of the matrix, looking at the political cost of investment protection. And here we're primarily focused on the impact of the treaty on the ability of the government of the day to adopt the kinds of policies that it wishes to adopt. This is often referred to as a threat of lost policy space, a threat to regulatory sovereignty, or a possibility of regulatory freeze. Now, the key question here is the extent to which an investment treaty will actually prevent or discourage the government from regulating as it wishes beyond any such limitations as may exist in domestic constitutional law or statutory law or the like. Now, note here that it's very important not to double count economic and political costs. Under international investment law, in most cases, the investor can receive only damages and cannot actually prevent the state from regulating. What this means is that a state can choose. It can choose to maintain the challenge regulation, but to pay damages. In that case, it suffers economic costs, but not political costs. On the other hand, it can choose to avoid or rescind the regulation, and then not be liable for damages. In that case, the state would suffer political costs and not economic costs. Now let's think about how we might apply this framework to a hypothetical case. And again, for illustration purposes here, we're talking specifically about a hypothetical investor protection treaty or FTA chapter between the US and the UK, analyzing things from the UK government's perspective. And now, first, let's look at economic benefits. So most of the policy debate here, as I mentioned, is about whether BITs are effective at promoting FDI. In fact, empirical research on the effects, if any, of investment treaties on FDI inflows are really quite mixed. And so existing studies are all over the map. Some find a massive positive effect of investment treaties on foreign investment flows. Some find no effect. Some find counterintuitively a negative effect. Moreover, these studies generally suffer from very serious methodological and data limitations, such that in my view, we really need to take all of the results with a large grain of salt. But most importantly, I think there's very little theoretical reason to think that investment treaties should have much of any effect on foreign investment flows where the host state already has a strong rule of law. In the case of the UK, it is incontestable that domestic legal and political institutions are of very high quality. There's no evidence that the UK government systematically mistreats foreign investors in the way that would be actionable under investment treaties. And in fact, the UK already receives massive amounts of US FDI, even in the absence of an investment treaty. Therefore, we think there's probably a low probability that a US-UK investment treaty would actually promote more US FDI into the UK, a very low probability, in other words, of meaningful economic benefits. Now let's move on to economic costs. And here, our conclusion is that there is a medium probability of a meaningful increase in economic costs for the UK. And this is because investment treaties, by design, offer investors greater rights than they enjoy under domestic law, and because a US-UK investment treaty would cover a massive amount of existing and future investments, containing a huge pool of potential claimants. Now, for example, in the UK, it is very difficult to challenge an act of Parliament on rational basis or other kinds of grounds. An investment treaty, though, is very likely to allow such challenges under the treaty's fair and equitable treatment or other provisions. US investors are notorious for being aggressively litigious, and they will be likely to bring claims, even to bring long-shot claims against the UK, and they may even win some of those claims. And even if they don't win, the UK government will have to pay it to defend itself. It will have to pay to develop a defense capacity. And while the amount of those costs is not likely to be massive, the UK government's not going to go bankrupt because of an investment treaty. Those costs can still be meaningful. An important caveat here, though, is that we lack enough data to reliably estimate the magnitude of those costs. Now let's move on to political benefits. Political benefits of a US-UK investment treaty are probably pretty low. Investment protection is unlikely to meaningfully depoliticize US-UK diplomatic relations, as those relations are already very strong. Indeed, the US and UK are exceedingly close allies, and there's no reason to think that in the absence of strong investor protections, there is likely to be gunboat diplomacy between the two. In fact, we think that currently the threat of serious political tensions between the US and UK relating to foreign investors is already quite low, even in the absence of an investment treaty. As an illustration, note the BP Deepwater Horizon episode, which resulted from the drilling platform accident in the Gulf of Mexico. It's not caused any obvious political crisis between the two countries. In fact, I would add that you might think about whether a diplomatic crisis would have been more likely should BP have had the ability to challenge its environmental liability under international investment law. If BP had done so, if it had sued the US under an investment treaty for its treatment in the wake of the disaster, I think there'd be much less enthusiasm in the US government today for investor-state dispute settlement in TTIP. Now let's look at the final quadrant, political costs. And here we're focused on the flip side of economic costs. That is, would an investment treaty with investor-state arbitration increase the risk that the UK government would be prevented or discouraged from implementing the policies that the government of the day wishes to implement? And for reasons similar to those already discussed for the economic cost quadrant, we think the risk or cost here is probably on a medium level. The huge number of investors that will be covered by a UK-US investment treaty, combined with the probability that the treaty will contain more generous rights than currently exist under UK law, means that there would be a meaningful increase in the probability that the UK government would avoid taking preferred regulatory actions in the face of investor threats to sue. And so what's the net takeaway point from the application of our cost-benefit framework? We think that, on net, an investment protection treaty between the UK and US would not be rational for the UK. This is because the treaty would likely impose greater costs than benefits. It will be unlikely to increase FDI flows. There is no need for it to depoliticize already strong US-UK diplomatic relations, while on the other hand, it will provide foreign investors with more opportunities to challenge UK policy decisions, winning either monetary compensation or forcing a change in policy. Now, in my last substantive slide, I want to conclude by briefly discussing some of the challenges of cost-benefit analysis of the type that I presented here. Those challenges should, for the most part, be relatively obvious. The main issue is the lack of data on the relevant theoretical consequences of investment protection and of the uncertain probabilities that certain costs or benefits will materialize. As I already mentioned, empirical studies on the link between BITS and FDI are all over the map in terms of results, while moreover, those studies suffer from very serious methodological and data problems. FDI data is of very poor quality. It's often not comparable over time or across countries. It's often not available bilaterally. It's not available at the sectoral level, where we might expect BITs to have different effects depending on the sector of the investment. And I think what's probably more important than the data problems, though, is that the underlying theory that BITs should cause big increases in FDI is highly problematic. It ignores alternative means that investors have to protect themselves. It ignores differential levels of political risk across different sectors. And it ignores the reputational interest that states have in treating investors fairly. It probably also exaggerates the efficacy of a law as a tool to adequately address the kinds of politically charged conflicts that do occasionally arise between investors and host states. As to the data regarding political benefits, there's really no empirical data about the ability of investment treaties to depoliticize investment disputes. And there's also really no good empirical data on the extent to which treaties might actually cause regulatory freeze. Analysts routinely talk about depolitization and regulatory freeze, but they have not defined the concepts with enough precision to allow the theses to be tested. The regulatory freeze hypothesis in particular suffers from the problem of how to identify regulations that never happen. that problem is in many cases, I think, intractable. But despite these empirical limitations that I mentioned and others that I haven't, I think the analytic framework illustrated in the presentation can still be useful. For one, it points governments towards the kinds of data that they might aim to collect. For example, is there a history of investment-related diplomatic disputes with the potential treaty partner? How often have investors threatened legal action in the past for regulatory decisions? And second, our basic analytic framework, combined with guesstimates of the relevant values, can help structure and inform government thinking about investment treaties. And in some cases, it can even be used to generate plausible net conclusions as to whether investment protection is worth it. For example, in the case of a US-UK investment treaty, we think it's pretty clear that such a treaty is probably not worth it. That conclusion has obvious practical implications for the debate over investor-state arbitration in TTIP. It suggests that for the UK and other highly developed EU member states, removing investor-state arbitration from the negotiations may actually improve net treaty outcomes for the EU. Though that conclusion itself depends, and this is a further complication that I can't deal with here, on whether US negotiators would demand concessions in other issue areas in exchange for weakening TTIP's investment chapter. Now let's move on to the last slide. I've only been able to touch quite briefly and rather superficially on a very complex set of issues. But for those of you interested in a more full discussion, I recommend that you take a look at the three reports that are cited in this last slide and upon which this presentation was based. And if you have any questions about the presentation or about the underlying articles, please feel free to contact me by email. I hope you've enjoyed the presentation, and thanks much for listening.